Good morning, everybody. I will call this meeting of the Senate Judiciary Committee to order. Will the Secretary please take the roll?
Senator Flores, Senator Orenshall,
Present.
Senator Lang, Senator Wynn, Senator Hansen, Senator Krasner, Senator Ellison, Chair Scheibel.
And I am here. Please mark those members who are not present when they arrive. If they don't make it, then just mark them absent, excused. As always, we're all trying to serve in multiple committees, present in multiple committees, be in multiple committees at the same time. And I'm very pleased for all of you who are able to be here today, right now. Thank you for accommodating our call of the chair meeting time. I know that this time of session, we're even more fluid with who is presenting and when. So I'm just going to ask, is there somebody here to present AB 344? That's fine, that's fine. This is not a test. It is just a practical question. Is there somebody here to present AB 541? Cool. How about AB 550? Also excellent. AB 320, any takers? I did skip over AB 381. I do see our presenter here for that. We are posting an amendment to Nellis and also bringing down copies for the committee. So I want to get those before we open up that hearing. But there is somebody here to present AB 320. All right. I will open up the hearing on AB 320.
Hello, Jovan Jackson for the record. I am happy to present AB 320 with my co-presenter, Nick Shepak. It's a pretty simple bill, straightforward bill. It's a bill basically protecting those individuals, make sure that they have access to court, access to justice, and access to a fair day in court. I will pass the presentation to Mr. Shepak.
Thank you, Chair and committee members. I'm Nick Shepak, N-I-C-K-S-H-E-P-A-C-K. I'm the Nevada State Director of the Fines and Fees Justice Center. Hopefully this one will be a little shorter than last night. As the Assemblyman mentioned, it's a fairly simple bill. So what we found out is we ran into some problems in courts, particularly in Clark County, through our partners who were doing court watching, where individuals were being denied access to court based on their attire. We have individuals who are facing eviction, who do not have to go to eviction court, do not have access to their clothing. We have expanded our homeless ordinances where individuals do not even own proper attire, or what we would consider proper formal attire. And then there's individuals who pick up their first misdemeanor charge. They take 3 buses in 120-degree weather. They mistakenly wear shorts. They don't have a defense attorney to let them know that they need to be wearing pants, and they are denied access to court. What this bill does is simply not allow you to the courts to add fines, fees, give them a failure to appear on their record, or issue an arrest warrant if they actually show up for their court date, and then the judge decides to deny them access to court based on their clothing. The judge still has the discretion to say, we're not going to be hearing your case, we do not believe you're properly dressed. They just cannot levy these additional penalties on those individuals. That's the bulk of the main section. The second section allows the Division of Parole and Probation to enter into programs with community partners to run pilot programs for job training. We amended this to make it a may instead of a shall, but we have spoken with multiple nonprofits and community groups that are excited to have this in statute so that they have an opportunity to work directly with parole and probation and ensure that people have access to job training once they get out of prison. And that's the bulk of the bill, and we'll be happy to take any questions.
All right. Thank you so much for your presentation. Are there questions? We'll start with Senator Orenshall.
Thank you very much, Chair, and thank you to the sponsor and the presenter. I really like Section 1.3 because, certainly I think down in Southern Nevada, as we're seeing, our homeless brothers and sisters population getting bigger, and folks who don't have access to, washer, dryer, get to a laundromat, to be able to, have clothes that normally people used to expect back in the old days for going to court. I mean, it just horrible to me, the idea that someone might be told, leave, and then a warrant might be issued for them because they didn't have the proper attire. So I think this bill is so timely. I mean, I just thank you for bringing it. I guess it's more of a comment. Thank you, Chair, for indulgence.
All right. Senator Ellison.
Thank you, Madam Chair. Is these people that are already incarcerated at the time, is that correct?
Nick Sheepak, for the record. No, this one.
I can't hear
Nick
you.
Sheepak, for the record. Can you hear me?
Is your light on?
Yeah.
Oh, okay. Go ahead.
Thank you, Senator. Are we good?
Yeah.
Awesome. These individuals are not currently incarcerated. Most of these people would be individuals who, say, had a misdemeanor, say a trespassing case, or any of the variety of things. They get a court date, and they have to come in, or an eviction. They have to go to eviction court. They come in, and they just don't have access to the types of clothing we wear in this building. And we have seen that in some courts, they are turned away. And what we're trying to make sure is that they don't get any extra punishments. If they take the time and the effort to show up for their court date, even if they're turned away, we don't want a warrant issued for their arrest or any additional fines and fees levied against them, because they did make the effort, they did show up to court, they just unfortunately were turned away due to not having the proper attire.
And what I was wondering is if these are people off the street or somebody that just might show up with not a lot of clothes on, that's when they were turned away.
Nick Sheepak, for the record. These would be individuals that may be off the street, they may be homeless and have picked up a charge, or they may have a home, they may have taken the bus, but these are individuals that are currently not incarcerated. What we've seen is it's generally individuals who are in clothing that is tattered, worn, or individuals in improper clothing like shorts, right? On a really hot day when we saw specifically an individual who took 3 buses, 120-degree weather, absent-mindedly, he was like, I'm going to be on buses all day. He wore shorts. He was turned away from court. We just don't want that individual to face any additional punishments if the judge decides to turn him away.
Jovan Jackson, for the record. This could also apply to working folks, construction workers, plumbers, folks who just got off of work and their court date is this time. They just got off of work and they're heading into court. So this also protects those individuals and makes sure that they don't get denied for coming in a work uniform.
All right, Senator Hansen, go ahead.
Thanks, Madam Chair. A little bit of a question of, is that our authority to be telling the courts how people shouldn't dress in the courtroom? I mean, a couple things too, I've seen guys with severe obscenities on their shirt, like F you judge or something like that. I'm just kind of wondering, where do we draw the line? Because is there anything in the Nevada revised statutes right now that require the courts to deal with decorum in the courts or appearance? Frankly, I want to keep the standards up, but I do understand. Spend a lot of time, frankly, in justice court, and you go into a justice court, and exceptionally rare to actually see anybody with a suit or tie on or anything. They're very casual, like a plumber would be, frankly, coming into those. In fact, I've been one. So, and just the separation of powers kind of a thing. Do we have the right to tell them that? I do notice in the bill it does say urge, so it's not mandatory. So I assume we leave them with that discretion. It's more like we want to make sure that if somebody does show up, that the judge will take into account maybe circumstances where this is the best attire they may have, kind of a concept. Is that where you're going with this?
Nick Sheepak, for the record, and thank you so much for the question, Senator. Yes, actually, Section 1.3, we worked with the judges of limited jurisdiction on that section. They had the language that they urge. So it's not a mandate, right? The legislature is urging this. The section that I do think they may have somewhat of an issue with is section 1.7, but from our perspective, this body sets penalties and often decides when a penalty can and cannot be issued. So a judge can still absolutely deny somebody to court. I would also say that if somebody wore the FU in with the judge's name, you could hold that individual in contempt. That would be, right, that's an aggressive type of thing that this isn't really trying to address. But we tried to strike a balance with this where we ensure the court remains and the judges have the discretion to say who gets into their courtroom. They can decide if that's based on attire or not. They just simply can't levy additional penalties against those individuals if they deny them access to their courtroom.
Very good. Thank you, Madam Chair.
All right, we'll go next to Vice Chair Flores.
Thank you, Madam Chair, and thank you for the presentation. I was curious to know, are the courts now reporting when they're turning individuals away? Do we have access to that data?
Nick Shepak, for the record, we have looked, but we have not been able to access data specifically on individuals turned away for attire. And then there were two separate issues where some we know of people making it to the actual courtroom and not being seen, but we also know of individuals who have been turned away by bailiffs, like at the front when they're attempting to enter the courtroom, but we have not been able to find any specific data.
And I know we're late in the game, and I am not trying to blow up a bill. I support what you're doing. I'm just curious to know if we could consider, and maybe it's a conversation for next session, but that we impose that requirement, that the court have to report how many folk they're turning away, create 3 categories so we know why. That will allow us to come back to this body and then say, look, in 2025, we had X amount of individuals turned away for clothing. Here's kind of the cited reason. I just think that would help us really build a strong case, one way or the other. Maybe it's not happening as much, and the courts are saying it's not happening as much as we think. It protects them in that way. Or it protects this side of the argument, saying it's a huge problem when an individual now has a warrant simply because they were turned away, right? And so I'm very supportive of it, and I'm not trying to blow up your bill. We're 5 days away from this thing. But I was just curious to know, and just throwing it out there as food for thought.
Jovan Jackson, for the record. There is no data currently, but I will say from personal experiences, I have been denied entry from court based off my tire off shorts, even as a, not as a defendant, but, just someone participating in court. And I have seen other people turn down, entry to court. So there's no data, but I have personally experienced this myself.
And Nick Shepak, for the record, thank you for the question, Senator Flores. And I agree. I would love to see more reporting and more data coming out of the courts. I do think that's probably a next session. We could do a whole bill on different information we want from the courts. I've never been able to run a information gathering piece of legislation with the courts or any other criminal justice entity that didn't end up with a note, usually fairly significant, on it. So I at this point, I think that we would enter into a note, physical notes from the court if we tried to add that to this piece.
Makes absolute sense. And I'm more than willing to work with you, Assemblymember Jackson, well, all 3 of us, and see if there's something we can do and try to avoid that. We'll talk about it in the interim. Thank you.
All right, any further questions on this bill? Not seeing any, we will move to testimony in support of AB 320. Anybody wishing to testify in support in person is invited forward to do so now in Carson City or Las Vegas. I don't see anybody in Las Vegas, so we will start here in Carson City.
Good morning, Chair Scheibel, committee members. Angela Knott from the Washoe County Public Defender's Office. ANGELAKNOTT. We are in support of AB 320. As a deputy public defender, I actually have had clients who were turned away based on the clothing that they were wearing. We have a lot of clients who need to do steps before even getting to the courtroom. They have to go get drug tested. Sometimes they have to go to the mental health center and get their medication, and then they still find their way to court and they're showing up. the worst thing we can do is turn them away after they've taken so many steps to make sure that they're there. In our office, we have actually started a clothing closet, and we actually do help a lot of our clients and their family members who are there in support. We give them clothing so that they can get entrance to the courtrooms, because sometimes even like a loved one can't enter the courtroom based on the wrong tank top or the wrong clothes. And so we do help provide clothing when we need to. But that's just this extra step, and if we don't have to go to that extra step and we can just allow entry and allow the process to work, I think we will see better results. So for these reasons, we support AB 320. Thank you.
Good morning, Madam Chair and members of the committee. For the record, my name is Quentin Savoie. That's Quentin, S like Sam, A like Apple, V like Victor, WOIR. I'm the president of the Las Vegas branch of the NAACP. We are in strong support of Assembly Bill 320. This is exactly the type of policy that should be considered the holistic approach to a person, so that they are not hit with barriers and bumps along the way. When we want people to engage in our justice system, it should be less intimidating as possible and as convenient as possible, because in many instances, folks have made a mistake and they're just trying to make restitution and make their mistake right. So eliminating barriers such as dress code so that folks can actively participate and get back to their lives is the right way to go. We applaud this measure, and thank you so much for your support.
Thank you, Chair, members of the committee. Harrison Epstein, Harrison Epstein, a legal extern with the Clark County Public Defender's Office. AB 320 is a valuable reminder that access to court and access to the legal system is vital for a functioning society. For indigent clients, getting to court can be its own battle. Our clients are often working jobs where getting time off to go to court is a challenge. They may be navigating public transit or walking early in the morning to be there when the Clark County Regional Justice Center opens at 7 in the morning. There are many barriers, and we believe that taking down these barriers is a benefit to all. We're also supportive of the potential pilot program outlined in Section 5. Thank you.
Good morning, Chair. Am I good? Okay. Good morning, Chair Scheibel and committee members. My name is Denise Heredia, Heredia, and I'm the Associate Director of Return Strong. Not further punishing individuals for the clothing that they're wearing when appearing in court is a matter of just basic fairness and human dignity. Successful reentry depends heavily on the resources and support available to people when they are leaving jails and prisons, and we need fewer barriers, not more, on the path to a just and rehabilitative system. So we do urge your support on the passage of this bill. Thank you.
Good morning. My name is Tia Smith, TIASMITH. I'm a policy attorney with ACLU of Nevada. I will just ditto all the remarks before me, but we very much support this bill and hope the committee will as well. Thank you.
All right, excuse me, I think that concludes in-person support testimony. So we'll go to the phones, please, for support on AB 320.
If you would like to testify in support of AB 320, please press star 9 now to take your place in the queue.
Good morning, Chair Scheibel, members of the committee. My name is Ben Innes. That is Beniness. I'm the coalition manager for the Nevada Housing Justice Alliance. We are a statewide coalition of grassroots organizers, community advocates that work directly with tenants throughout the state. I appreciate you, Chair Scheibel, for hearing this bill this morning, and Assemblymember Jackson for bringing this important bill forward. I've spoken about this before in this committee, but during the last interim, we launched an eviction court watching program where we observed over 600 hearings throughout the interim. Throughout the program, we ultimately saw an environment that could feel stacked against tenants. In the worst case scenarios, could easily feel like tenants could be, in some ways disrespected, dismissed, and treated poorly. And that's why we think this bill is so important to reduce as many barriers as possible in order to increase access to due process and justice in what would already be a very trying, difficult, and traumatic time. And that's why we urge your support. Thank you so much.
Good morning, Chair Scheibel and members of the committee. For the record, my name is Tara Webster. I'm calling on behalf of the Progressive Leadership Alliance of Nevada. PLAN believes that being denied to appear in court based on attire is an inherent bias against those who are living in poverty, facing mental health crisis, those navigating public transit, or those who simply are balancing work to attend court. AB 320 is a common sense bill that offers basic human dignity and reduces barriers for members of our community who are trying to do their best to participate in the justice system. We strongly encourage the committee's approval of AB 320. Thank you.
Good afternoon, Chair and members of the committee. My name is Sarah Neza. I'm here to express my strong support for Assembly Bill 320. As someone who has spent significant time court watching in eviction proceedings all across Nevada, I've witnessed firsthand how our courtrooms can become unwelcoming and even inaccessible spaces for the people who need justice the most. I've seen tenants, often frightened and unrepresented, show up on one of the most stressful days of their lives, only to be judged not just on the facts of the case, but on what they're wearing. In many of these cases, tenants are low-income individuals or families on the brink of homelessness. Some arrive wearing work uniforms or whatever clean clothes that they could manage. Others, already experiencing homelessness, simply don't have access to professional attire. Yet the courtroom should never be a place where someone's access to justice is determined by their wardrobe. Assembly Bill 320 addresses this inequity in a simple but powerful way by ensuring that courts cannot deny access based solely on a person's clothing. It upholds the fundamental principle that justice must be available to all, regardless of their socioeconomic status. This bill does not eliminate decorum or respect in the courtroom. What it does is remove an arbitrary barrier that is no place in a just legal system. If someone is being evicted, charged, or seeking relief, they deserve to be heard, period. Their clothing should never speak louder than their circumstances. I urge you to support Assembly Bill 320 and stand for dignity, fairness, and equal access to justice for all Nevadans. Thank you.
Chair, you have no more callers in support at this time.
All right, we'll go to testimony in opposition. Anybody wishing to testify in person in opposition is invited forward to do so now. We will start here in Carson City.
Good morning, Madam Chair and members of the Judiciary Committee. My name is Manvi Mumlaneni, M-A-N-V-I, M-U-M-M-A-L-A-N-E-N-I, and I'm with Tom Clark Solutions. I'm representing the Nevada Judges of Limited Jurisdiction. We support Section 1.3 of AB 320, but we oppose Section 1.7 of this bill because of the Nevada Separation of Powers Clause, Article 3, Section 1 of the Nevada Constitution. Thank you for your consideration.
Good morning, Chair Scheibel, members of the committee. My name is Andres Moses, A-N-D-R-E-S, last name Moses, M-O-S-E-S. On behalf of the 8th Judicial District Court in Clark County, Nevada, I want to echo the remarks from the Nevada Judges of Limited Jurisdiction on the separation of powers concerns. We appreciate the intent. Access to justice is very important to my judges in our court. I think we have a big bench. We have 58 judges. We have 100,000 cases a year. I think by and large, my judges are pretty happy when people show up, but we do feel like imposing a restriction on the judges to be able to regulate the decorum of their courtroom does go too far, so we are concerned with 1.7, and so that'll be my remarks. Thank you.
Thank you, Chair Scheibel, members of the Senate Judiciary Committee. My name is John Jones, here on behalf of the Nevada District Attorneys Association. I want to say I did not speak in opposition to sections 1.3 or 1.7 on the Assembly side, because on the Assembly side it had the words formal or professional attire in it. Section 1.7, as it reads now, says based solely because of the attire of the victim. And what I'm concerned about are situations, and Senator Hansen touched on this, are where the attire contains offensive messages or an anti-victim statement on the shirt, or a statement against the judge on the shirt. The way I read section 1.7 is it would prohibit a judge from sanctioning that individual for saying something negative about the victim in open court. Court should be a place where everybody can come and feel safe. So I have concerns about how section 1.7 could be read. I fully support people coming as they are. I want them in court because delays happen when people don't come to court. But when they have offensive messages on their attire, I think the judges should be able to take action.
Thank you. I don't see anybody else coming forward to give opposition testimony, so we will go to the phones, please, for opposition.
Chair, your public line is open and working. You currently have no additional callers at this time.
All right, we'll go to neutral testimony. Anybody wishing to testify in neutral in person is invited forward to do so now. I don't see anybody coming forward, so we'll go to the phones for neutral testimony.
Chair, your public line is, you have one additional caller. If you would like to testify in support, please press *9 now to take your place in the queue.
Good morning, Chair, and members of the committee. This is Dora Martinez, with the Nevada Disability Action Coalition. I wholeheartedly support this bill, Madam Chair. You know me, you know I have a guide dog, and I went to court as an eyewitness. You have away from them, and I did not know what I was clean, but I did not know what shirt I had, and I'm not going to tell you what it was because it's my Kim shirt. So I was not turned away, but this is a good bill for people who needs it, and person like myself who is blind, and sometimes the app was not available then to read my shirt. So I support this bill. Thank you. Have a good day.
Chair, you have no additional callers at this time.
Thank you so much. I'll let the record reflect that Ms. Martinez's testimony was in support. We understand the technical issues with getting into the queue at the right time, and our broadcast does an amazing job keeping so many people on track all day, every day in this building. So with that, I think that concludes testimony. I will invite the presenters forward. If they have any closing remarks, please come on up and give your brief closing remarks. You couldn't hear him, but Senator Ellison turned around and said to me, "Clothing remarks?" It was very clever.
No clothing remarks. Jovan Jackson, for the record. I just want to thank the chair and the body for hearing this, and I want to thank Mr. Jones for highlighting that, and we are willing to take a amendment, and I'll let Mr. Shepak have the last words.
Thank you, Chair and committee members. Nick Shepak for the record. Yeah, I do not believe we have an issue with taking an amendment to carve out offensive clothing. As far as the separations of powers issue goes, I think reasonable minds can disagree on when the legislator can decide if you set penalties or not. We've had many conversations in previous sessions on what happens when somebody fails to show up to court or fails to make a payment on a traffic ticket. Can you suspend their driver's license? Can you levy additional penalties? We've passed those bills in this legislature. I don't see this as very different, but I think, again, reasonable minds can disagree. But we'd be happy to take an amendment to carve out that offensive material. Thank you very much.
Thank you. All right, that concludes our hearing on AB 320. I will close that hearing. I understand that the assembly is going to go to floor at 11:30, but I do still want to try to hear AB 381 before that time. I completely understand if the sponsor has to leave to go to floor, but hopefully 30 minutes is enough time for the presentation and questions at least. So I will go ahead and open up the hearing on AB 381.
Good morning, Chair Scheibel and members of the Senate Judiciary. My name is Melissa Hardy, and I'm the Assemblywoman representing District 22 in the Henderson area. I appreciate the opportunity to be here this morning to present AB 381. Presenting with me today is Rebecca Goff with the Humane World for Animals. Justice for Reba, that was the message so many of us heard loudly and clearly in July of 2024 after a bulldog was trapped in a plastic bin with the lid taped shut and left behind in a grocery store dumpster. Amazingly, Reba was rescued, but sadly the heat stroke was too much for her to overcome and she did not make it. 2 people were eventually arrested for what happened to Reba. However, the penalties didn't fit the crime. AB 381, affectionately referred to as Reba's Law, will ensure that heinous and willful acts of abuse, neglect, and harm carry stiff penalties and consequences. While no abuse or neglect in any form should be committed or tolerated, this bill specifically addresses those who knowingly and willfully commit such acts or allow them to occur and establishes harsher penalties when a death occurs from such actions. I would like now to turn it over to Rebecca Goff from the Humane World for Animals, and she will go through the sections of the bill that pertain to her, and then I will go through the penalty sections of the bill. Thank you.
Good morning, Chair Scheibel and members of the committee. My name is Rebecca Goff, and I'm the Nevada State Director for Humane World for Animals, formerly known as the Humane Society of the United States. Strengthening animal cruelty laws serves to protect the public health and safety. Research indicates a correlation between animal cruelty and other forms of violence, including domestic abuse and crime. By imposing stricter penalties, Nevada can deter individuals who might otherwise engage in broader criminal behavior, thereby enhancing community well-being. This legislation represents a critical advancement in Nevada's commitment to animal welfare by proposing tougher penalties for acts of cruelty and torture and updates other related issues, such as Section 3, which details the process for the removal and care for the animal and the notification for the owner. This bill removes the authority of the court to have the animal sold at auction and replaces continued in care with the word forfeited. Abused and neglected animals deserve to receive medical care and other attention they need to stop their suffering and survive, and eventually find a new home. They're more than just property to be sold to the highest bidder. And forfeiture is important because the seizing agency eventually needs the legal authority to transfer ownership of the animal to a shelter, rescue, or new home. This bill also removes the exemption for any animal which is located on land being employed for agricultural use as defined in NRS 361A.030. There's no reason to remove protections for any animal simply based on where the animal is located. Section 6 updates the law to reflect that the new provisions do not prohibit the humane euthanasia of an animal by a vet tech, or euthanasia tech if deemed necessary to end the further suffering of the animal. Section 7 has the same updates as seen in Section 3 regarding the process of notification, hearing requests, and forfeiture of the animal. And Section 8 authorizes the court by temporary order to enjoin the adverse party from taking possession of an animal that is owned or kept by the adverse party. And I will pass it back to the Assemblywoman.
Thank you, Melissa Hardy, for the record. So Section 1.4 establishes the new enhanced criminal penalties for animal cruelty. Subsection 1 of Section 1.4 punishes those who torture, maim, mutilate, or kill an animal kept for companionship or pleasure, or any cat or dog. If the act of animal cruelty is done knowingly or recklessly, for a Category D felony, punishable by 1 to 4 years in prison. If the act is done willfully, for a Category C felony, punishable by 1 to 5 years in prison. If the act of cruelty is done to threaten, intimidate, or terrorize another person, is guilty of a Category B felony, punishable by 1 to 6 years in prison. Subsection 2A of Section 1.4 punishes those who willfully and maliciously restrain a dog with a gross misdemeanor. Subsection 2B of Section 1.4 punishes those who willfully and maliciously abandon an animal with a Category C felony. Finally, subsection 2C of Section 1.4 punishes those who whose willful and malicious acts lead to the death of an animal with a Category B felony punishable by 1 to 6 years in prison. And then going to Section 5, this makes similar penalty structure changes to the police animal statute. A person who engages in an act of cruelty on a police animal would be guilty of a Category C felony. A person who kills a police animal would be guilty of a Category B felony. So at this point, I'm happy to take any questions. Thank you.
Thank you. Before we get to questions for you, I have a couple of questions that I want to go over with legal, if that's okay, because you did speak to sections 1 and 5 of the bill. I think there were a couple of sections that were amended on the assembly side that my members are going to have questions about, and so I was hoping that we could turn to section 4, I think it is, subsection 7. It's on page 9. This is an affirmative defense. Wait, maybe it's not on page 9.
Is it page 11?
Thank you. It is on page 11, on line 19. I was wondering if legal could give us a little primer on what an affirmative defense is and how it works.
Thank you, Chair. An affirmative defense is a defense in which the defendant will introduce evidence which, if found credible, negates criminal liability for an offense. Commonly, you have affirmative defenses like self-defense is probably the most common one, entrapment. There are a number of statutory affirmative defenses in NRS also for specific acts like accessing a computer unlawfully. But basically, the defendant has to raise the affirmative defense and prove by a preponderance of the evidence that that defense is supported.
Thank you. I appreciate that. And I think those are all my questions for legal at this point. Let me open it up to the members to see if they have questions for our presenters. Vice Chair Flores.
Can you just please, rather than starting with vetting the bill, can you just walk me through where the bill ended in the Assembly, and then what changes we've made thereafter, and who we've done that with? Who was part of that working group? I'm just trying to understand where this amendment, how this amendment got to us.
Melissa Hardy, for the record. So I've worked on this bill for like 10 months, and when we had the hearing in the Assembly, you know, there were stakeholders. I worked with the DA, I worked with Ms. Goff, I worked with the public defender to address the concerns, and so then when it was work sessioned on the Assembly, there were additional concerns and things that had asked to be added to the bill. And so that's where we came to the first reprint and all of these amendments that you see here.
And maybe I could add a little bit more clarity. The amendment that we're looking at right now, it does say AB 381_R1 for first reprint down at the bottom. This is a conceptual amendment that takes the first reprint, which already had significant changes, and this includes some additional requested amendments from the district attorney's office, and maybe they could come down, or from the Clark County and the district attorney's office, and maybe you could come down and help explain the amendments to the first reprint that you're requesting in front of our committee today.
Thank you, Chair Scheibel and members of the committee. My name is Jeff Rogan, Jeffrogan, and I represent Clark County. The amendment that is before you today and that you probably are just reading through at the present moment was a collaborative effort with the criminal division of the District Attorney's Office in Clark County and myself on behalf of our Animal Protective Services to address just some minor technical cleanups that occurred in the drafting of the reprint and nothing more than that. And so with your permission, I can walk you through section by section some of the changes that affect the processes for animal control or animal protective services in our local governments and any civil court processes that are affected by the amendment. And then Mr. Jones will address any of the criminal matters that the amendment addresses. So first, if you look at the amendment that is in front of you, that Chair Scheibel indicated has AB 381R1 at the bottom. In section 1.2, it's the language that you see there is just a little bit of clarifying language. First, the intent of this subsection 2 in section 1.2 was to eliminate the existing law that required an animal control officer to seek a court order before humanely euthanizing an abused animal, and in its place provide flexibility by allowing a licensed veterinarian, a veterinarian tech, or a euthanasia tech to make a determination that an animal needs to be humanely euthanized. Again, this was for flexibility because sometimes seeking a court order took several days, and during that time, an animal that has no hope of recovery is unnecessarily suffering. So this will allow that decision to be made by an expert in the field and to more quickly humanely euthanize an animal that needs to be euthanized. Unfortunately, as in the reprint, there was this pop cap that was put in place, and if you technically read that pop cap where it says in a county whose population is 100,000 or more, that necessarily eliminated the ability of any county of a population less than 100,000 from humanely euthanizing an abused animal at all, with or without a court order, with or without a vet taking a look at the animal. And so we felt it necessary to eliminate that language. In addition, the green language in subsections A and B were necessary. It was brought to our attention by some of the smaller counties that there's, the initial language was just the vet, no court, no vet tech, no euthanasia tech, but the smaller counties made it clear to us that oftentimes there's not veterinarians that are going to be available to make that determination, and so we had to leave in the process of getting a court order because that may be the fastest. And also there may be vet techs that are available or euthanasia techs that are available and a veterinarian is not. And so we wanted to provide that greater flexibility for our smaller counties. In subsection 4 of section 1.2, that's also just some clarifying language that we caught. Existing law immunizes from any civil liability an animal control officer who decides to humanely euthanize an animal. Implicit in that is that the employer of the animal control officer would also not be liable, but we wanted to make that clear to avoid any unnecessary litigation. In addition, we wanted to add independent contractors because those are our vets and vet techs that would be coming out to make that assessment as provided in subsection 2 of section 1.2 as amended. And so we wanted to make sure that those vet techs and vets are making a determination about whether an animal should be humanely euthanized based upon their expertise and not anything like the potential for future civil liability. Moving on to section 1.6, you'll see in that section and throughout the remainder of the bill that sometimes we've crossed out references to sections 1.2 and replaced it with section 1.4. And the reason for that is just, it seems to be just a drafting mistake. Read technically, those sections seem to imply that if an animal control officer or a veterinarian violates any process provided in the new amended section 1.2, that they could be held criminally liable. That was not the intent, and if you actually read section 1.4 that goes through the criminal penalties, there's nothing in there about animal control officers or vets being held criminally liable for failing to follow those procedures as laid out. And so to eliminate any confusion in the future, we'd made those minor changes throughout the reprint. There's one other small change that you'll see throughout the bill. In the reprint, as opposed to existing law today, any reference to a number of days was listed as business days rather than calendar days. Right now, the law is calendar days. Business days, it's often unclear, primarily because now some jurisdictions only have 4-day work weeks. Some jurisdictions may have 5-day work weeks. Some courts are 4 days, some courts are 5 days. So the reference to business days now is not as clear as it used to be in the past. And in fact, in our justice system, we're moving away from references to business days in favor of calendar days for that very reason. And so we wanted to leave it as it is today, that any reference to the passage of a number of days is calendar days. So again, these are just minor cleanups. And lastly, I do want to address one change before turning it over to Mr. Jones. You'll see in subsection 2 of section 3, which is on page 5, line 192 of the proposed amendment, we're adding the words "or the humane euthanasia of the animal." This might seem like a substantive change, but it's really not, because all that we're doing in this subsection is harmonizing 2 statutes. Those are NRS 574.055 and 574.203. 574.203 is in section 7. Both of those statutes address how a person can contest the seizure of an animal after it's been taken by an animal control officer. But they, as they exist today, they provide 2 different processes based upon whether a person is arrested or not arrested. The reprint was intended to make those identical so that there's not any differences between the processes if a person's arrested or not arrested. And for some reason, in section 7, the language "or the humane euthanasia of the animal" was left in, as was intended with the initial bill, but it was omitted in this particular subsection for some reason, and we just think it was a technical oversight, and we're just reinserting that to make sure that those 2 statutes going forward are exactly the same. So I'm ready to turn it over to Mr. Jones now, but if you have any questions about that, I'm happy to answer them.
Thank you, Chair Seibel, members of the Senate Judiciary Committee. My name is John Jones here on behalf of the Nevada District Attorneys Association. And just expanding on what Mr. Rogan said initially, this amendment was put together by several municipal governments, counties, and the DAs as well. So it was a collaborative effort amongst us, working with our various animal cruelty deputies and animal cruelty officers so we can make a 381 better. I'm going to start with the criminal provisions in section 1.6. As Assembly Member Hardy noted, there are criminal penalties outlined in section 1.4, but the amendment is not proposing to make any changes to that. So I'm going to move to section 1.6, which in the reprint creates this new temporary restraining order that is filed against the defendant from owning animals, from threatening the owner, others, etc. And in the criminal setting, we don't really use temporary restraining orders. A court can issue an order in a criminal case ordering the defendant to do something or not to do something. So what this amendment does to 1.6 is just stylize this as an order like we typically use in the criminal context. So we're getting rid of the words temporary restraining and just calling it an order. Turning to section 2, and I will say up until this point, most of the changes have been technical, just to conform with what we're doing now or making clear things that we wanted to change with 381. The change that I'm proposing in section 4 on page 4 of the amendment is more substantive in nature. So this is one of the more substantive changes that we're making, and that is to retain our current definition of torture or cruelty. In the original version of 381, we proposed to keep this definition the same. In the reprint, it was split between torture and cruelty. And there are some arguments for doing this, but it's my opinion and the opinion of others that because this wasn't necessarily vetted, there are some unintended consequences that could result by splitting the definition at this point. For example, you notice in the definition of torture in the reprint, it removes omission from the definition of torture. So if I do not feed or water my cat or dog for a period of time, and I do that intentionally, maliciously, that would not be an act of torture. Because that's not an act of torture, if I if I omit to feed or water my animal to the point of starvation, I could not enhance that crime as a prosecutor and charge a felony. It would be a misdemeanor under every circumstances except if the animal died. That's one of the unintended consequences by splitting these definitions and removing the word omission from the definition of torture. So what we're concerned about are examples like that I don't think we properly thought through. And this could be the policy direction we ultimately go down. But I think we need to think about it more, to be more collaborative about splitting this definition. And until we've gone through that process, our position is that we should retain our current definition of torture and cruelty to include every act, omission, or neglect whereby unjustifiable physical pain, suffering, or death is caused or permitted. And then finally, my last section is section 4, and this was touched on by the chair and in discussion with legal, and that's the affirmative defense. I will say from the outset that it is the preference of the Nevada District Attorneys Association that this affirmative defense be removed. I'll note that I am not aware, I think if you ask Ms. Goff on behalf of Humane World, are there any acceptable practices where physical discipline of an animal should be engaged in? And my guess is she's going to answer no. But if the committee decides to go down this path, then it's our position that we need more structure around what exactly we're intending when we use the word affirmative defense. Because I agree with legal's analysis that an affirmative defense does negate criminal intent. So what we're asking, if we're going to go down that road, that defense provide us notice not less than 21 days before trial about what specifically their intent is with respect to the affirmative defense, and give us witnesses. That gives us time as prosecutors to figure out if we can rebut that through our own witnesses. And this would all be done in preparation for trial. One of the things I'm worried about are with the definition of if the person reasonably believes that the person was engaged in reasonable discipline of an animal. That can be read several different ways, and arguably jurors of like mind could disagree. One of the examples that I've given regularly from my animal cruelty folks are taping the nozzle of a dog shut. So if a person has a dog that is barking too much or bites, and they decide that the reasonable discipline they're going to engage in is to tape the nozzle shut, does that mean it's not an act of cruelty? But anybody who knows animals knows that is one of the most dangerous things you can do to a dog with a nozzle, is tape its nozzle shut. That would really hinder our ability to get a cruelty conviction out of the statute. Now, there is a question about whether they did it willfully. Were they meaning to harm the animal when they did it? Or is it more of a misdemeanor negligent act? That is all currently within the defense's purview to argue, the defendant's purview to argue. But this, I think, would confuse the issue and in fact, weaken our animal cruelty laws. But if this is the avenue that the committee wants to go down, I think at least providing the state notice so we could think about witnesses that could come in and rebut that would be beneficial and at least help us in that instance. With that, Chair, Mr. Rogan is happy to answer any questions you guys have about the process. I'm happy to do to answer any questions you guys may have about the criminal statutes.
Thank you so much. And I think that Vice Chair Flores was kind of in the middle of asking a question when I called you up here. I am going to go back to him, but first I also want to get a couple things clarified from legal, just so we're all on the same page as we ask these questions. So first, I wanted to go to I'll go in order. Section 1.6, I'm not sure if this is a question for legal or for you, Mr. Jones, but I recall in this body, I think it was 2 sessions ago, working very hard on a bill that allowed any violation of a court order to be treated as a misdemeanor. So whether it is the court reasonably ordering a defendant to stay away from a victim's home, to stay out of all 7-Elevens, to refrain from smoking marijuana, or not to have contact with animals, we already have a statute in place that allows a judge to enter that order and for a violation of the order to be treated as a misdemeanor. And so my question is whether section 1.6A changes any of that, and B is really necessary in order to effectuate that policy goal.
John Jones on behalf of the Nevada District Attorneys Association. Chair Scheibel, I believe I know what statute you're referring to, and I believe that's an order prohibiting conduct against a victim. I believe that's the only scenario in which that new misdemeanor applies. So it would not apply to an instance where the judge is ordering a defendant to stay away from animals.
Okay, I appreciate that clarification. Maybe I just tell my clients that it's a misdemeanor to violate a judge's orders to get them not to do it. But I always give them accurate advice, okay? I just try to help them along to do what's best for them. I'm going to stop while I'm not too far behind and move to section 2. On section 2, again, not sure if this is more of a question for legal or for you, Mr. Jones. I appreciate that the amended version of the bill breaks out cruelty and torture, but I don't see anywhere in the bill that we have different penalties for cruelty and torture or treat them differently. So am I just missing it?
John Jones on behalf of the Nevada District Attorneys Association. Sorry, let me collect my thoughts real quick. So most of the animal cruelty prohibitions are spelled out in 574.100. And where this really comes into play is sub 1A, where a person shall not torture, unjustifiably maim, mutilate, or kill. Right now, the word torture and cruelty are used interchangeably. And so torture applies when you're talking about an omission where it still leads to the maiming, mutilating, killing of an animal, or torturing, maiming, mutilating, or killing of an animal. So if you fail to water it or feed it for a period of time, then that does meet the definition of torture, maiming, mutilating, or killing. You take out omission from the definition of torture, as the reprint proposes to do, then sub 1A would no longer apply. So you would then go down to sub 1C, which is deprive an animal of necessary sustenance, food, or drink. That would clearly apply. The problem is the penalty for that is a misdemeanor unless, pursuant to the new subsection 4, the animal dies. If the animal dies due to your failing to feed it or water it, then we could file the new category B felony. When you read subsection 1.4, sorry, let's see here, sub 2C. So if you violate the provisions of 574.100 and 574.110 and you cause the death, then it's punishable by a felony 1 to 6. But it's only in the instance of the death, because when you look at sub 1, it's a specific, violates the provision of paragraph A of sub 1 of NRS 574.100. I hope that makes sense.
That does. That does answer my question. I appreciate it. And with that, I will go ahead and turn it over to my committee. Okay, I'll start with Senator Hansen.
Thanks, Madam Chair. It's just sort of odd. When Senator Ellis and I were freshmen in 2011, we had a bill in front of Natural Resources dealing with this issue. And at that time, the law enforcement people were opposed to the idea of expanding it to felonies. At that time, the maximum penalty for animal cruelty was gross misdemeanor. And we had judges and everything else saying, look, we don't approve of animal cruelty, but we also know that these kind of things can really clog up the court systems. And we are very uncomfortable with the idea of putting people into prison for possible animal violations. The reason I bring that up is this has a lot of felonies in it. We've had numerous bills and comments about reducing our prison populations, and we always have a lot of interesting arguments as to why we need to reduce penalties, but for some reason we're constantly enhancing them when it comes to this particular category. How many animal cruelty felonies have you guys actually prosecuted in Clark County that you can, are we talking a dozen, 1,000? I mean, how big of a problem is it? And is this bill necessary? Is there some absence in law now that's preventing you from prosecuting abuse cases of animals?
Thank you. John Jones on behalf of the Nevada District Attorneys Association. That is a great question, Senator Hansen. And I'm going to start off by saying if there's one offense in which people freely reach out to our office, it's regarding animal cruelty cases. And in Clark County specifically, we've had several high-profile instances. Some were talked about during the presentation of the bill that have caused outrage. And outrage, quite frankly, is furthered when people learn about the current penalties in statute for the willful and malicious torture of an animal. It's a 1 to 4. And the problem with our current scheme is whether you torture it and the animal lives or you torture the animal and it dies, the penalty range is the same. It's 1 to 4 years. And the way our sentencing structure works in Nevada, there is not a lot of room with a 1 to 4 range in which to punish the vast array of torturing we can see with respect to an animal. So the original intent of 381 was to make the torture that leads to the death of an animal a 1 to 10. That was our original request. And there was some pushback from defense, there was some pushback from the committee that was too big of a range, and it made us out of step with some of our other crimes against a person. And I completely understand that argument. So through negotiations, we came to an agreement for a 1 to 6 enhanced penalty if the animal dies, and a 1 to 4 if torture occurs and the animal lives. With respect to stats, I can get you stats on how many animal cruelty cases we have. I don't have them with me, and I apologize for that, Senator. I probably should have. What I can tell you is what we've done in Clark is we have a lead animal cruelty deputy. That's currently Agnes Patello, and she has 3 people underneath her who work on animal cruelty cases. So we have enough of a problem in Clark where we have 4 deputies total who specialize in this area.
Okay, well then, are you aware of anybody that's actually been prosecuted on a felony level and went to prison for animal abuse in Clark County?
John Jones on behalf of the Nevada District Attorneys Association, yes. We have had situations where people have been sent to prison. And that is one thing I want to point out. I'm glad you mentioned that. Every offense that we're proposing to enhance today is probationable. So a judge, if they review the facts, they review the defendant's history and determine probation is appropriate, even if that act leads to the death of an animal, a judge can still grant probation. These are not mandatory prison offenses. But in situations where the act itself is heinous enough, or the record plus the act is heinous enough, a judge can send them to prison for what our position is, a length of time that more appropriately reflects the severity of the conduct.
All right, well, thank you for answering that. I think it was maybe 2 or 3 sessions ago, somebody produced a chart showing the average time and penalties for raping a woman versus the average time for serious animal abuse. And it was a little bit shocking because the animal abuse cases actually had more severe penalties on average how they were applied than situations involving abuse, if you will, of a human being. So I don't know, I'm just uncomfortable expanding felonies. We're trying to reduce prison populations. We're trying to come up with programs to try to reduce people doing whatever. And here we're enhancing penalties for things that not that long ago you guys felt should be a maximum gross misdemeanor type penalty. And by the way, a misdemeanor, which we talk about kind of lightheartedly, it's still 6 months in jail potentially and a $1,000 fine. A gross is 364 days basically. So it's not like those aren't significant penalties for horrendous animal abuse situation. Anyway, well, thank you, Madam Chair.
Thank you. I think Senator Flores had another question. Please go ahead.
Thank you, Madam Chair. Wanted to go into a different section that we were just discussing here internally, to section 1.8. Specifically, therein there's a reference to a ban. If it's a category D felony, the person will be banned from owning an animal for 7 years, category C felony, 15 years, and then category B felony, the remainder of his or her life. Can we, and that may, I know that that's not specifically your amendment, so maybe we could just have the presenter come back, unless there is questions on the amendment itself, since we already have you here up. But the question, so you know, is how that enforcement mechanism is going to work. How do they know when the, you know, how does somebody going to that household know that the ban went into effect on said date? How do we know when the completion of the 7 years has occurred? If I own the dog and my significant other has a ban, can that dog be in that same household? If it's my child that owns a puppy, but I have a ban, can that dog be in that household? I'm just trying to understand how that whole enforcement mechanism is going to work, and who's monitoring it, how are we enforcing it?
John Jones on behalf of the Nevada District Attorneys Association. Those are all great questions, Senator Flores, and I hope I'm not speaking out of turn by speaking for the sponsor, but this was not part of our original bill. Neither the sponsor nor I added this in. So in terms of speaking to the intent behind it, I don't think either of us are in a position to do that. What I can tell you that these are all felonies. Ban only comes into effect if you've been convicted of felony animal cruelty. And when you've been convicted of a felony, you do get a judgment of conviction, which does spell out specifically what you can and cannot do pursuant to that court order. So that is a mechanism by which a court could put those provisions into writing to notify the defendant. Further, in like the DV context, we do have other admonishments, so a court could use something like that. I agree that Section 1.8 does not spell that out, but those are the types of mechanisms that a court could use in order to notify the defendant of their ban and what the qualifications are.
And I guess the other question is, if we're in violation of that, so you have the felony conviction, there's a question of whether it was from the date of the charge. They make a mistake. I'm just hypothetically, I was charged in 2025, but the actual conviction didn't occur until 2027. So I made a mistake and I get the dog now a year early accidentally or whatever it is. So now what are the repercussions in that scenario? And again, what are the repercussions in the scenario where it's owned by my spouse and not me, or my son, not me? Or in a scenario where it's double-up homes are very common in a lot of different communities. It's owned by half the family. I'm just trying to understand how all this is gonna.
John Jones on behalf of the Nevada District Attorneys Association. That is another great question, Senator Flores. I could be wrong here, so I'm going to caveat my statement with this. I don't believe there is a criminal penalty prescribed for a violation of this new section in AB 381. If I'm wrong, I'm hoping legal or somebody else will correct me. Because there's no penalty prescribed, and the legislature is outlining an obligation or a prohibition, there's a general statute that says it's a misdemeanor if the legislature prohibits something but doesn't prescribe a penalty. So a violation of this section would be a misdemeanor for anybody who commits it, no matter what the offense and no matter how many times. I hope that answers your question, Senator Flores.
Understood. I appreciate the response.
All right. Are there any other questions from members of the committee? All right. Not seeing any. Thank you so much for presenting. Thank you for answering questions. As I mentioned earlier, we understand. Did you have something to add? Or we understand if you have to go to the floor. Okay. We'll go ahead to testimony in support of AB 381. Anybody wishing to testify here in person in support is invited forward to do so now. And I don't see anybody in Las Vegas, so we'll go ahead with our friends here in Carson City.
Thank you, Chair, members of the committee. For the record, Mike Cathcart, representing the City of Henderson. We want to thank Assembly Member Hardy for sponsoring this legislation and we are supportive of AB 381 with the proposed amendment. We believe the proposed amendment makes the bill technically sound and would be able to be operationalized by our animal control services. Thank you.
Thank you, Madam Chair, members of the committee. For the record, Kelly Crompton representing the City of Las Vegas. We also thank the Assembly member for bringing the bill forward and are supportive of the bill with the proposed amendment from the district attorneys. Thank you.
Thank you. I don't see anybody else coming forward to give support testimony, so we'll go to the phones, please, for support on AB 381.
Thank you, Chair. The public line is open and working. There are no callers at this time.
All right, then we'll go to opposition testimony, starting here in Carson City in person. If there's anybody wishing to testify in opposition, now is your time, but I don't see anybody coming forward here or in Las Vegas, so we will go to the phones, please, for opposition on AB 381.
Thank you, Chair. The public line is open and working. There are no callers at this time.
All right, then we'll go to neutral testimony. Anybody wishing to testify in neutral on AB 381 is invited forward now to do so. We will start here in Carson City.
Good morning, Chair and members of the committee. John Pirro from the Clark County Public Defender's Office. This bill has been through some changes. I just wanted to talk about a few things there. When Assemblymember Hardy had spoke about the bill, she spoke about the situation with Reba, and I can't speak too much to that because that's an open case, and our office represents one of the co-defendants. I will say, though, that we understand her wanting to change the law on that issue. There are some, if AB 381 was to go forward in its current form right now and reprint one, we have no opposition to the bill. However, we do have some oppositions to the proposed amendment by the district attorneys for a few reasons, both to, let's go through it. One of the problems that we have is with the business days. And Chair, if you'll remember, I remember when Jeff Dixon had the position that Rebecca Goff now has, you went through, and when a person gets arrested, we tried to make it so that they could at least have a chance to reclaim their pets. I will tell you that we just had a recent situation where a veteran got arrested with his 2 dogs. My attorney representing, from our office representing that client, immediately went into action to foster the dogs because he was going to be out soon. And the Animal Foundation, who is now letting everybody in Las Vegas know that they have too many animals there and they're going to euthanize animals, adopted one of the dogs out, even though we were in the process of trying to foster both before he got out. So this veteran, who his 2 best friends were his dogs, dog got adopted out of the Animal Foundation, and he only got to claim 1 back, even though we were in action immediately. So if you changed it to 5 days instead of 5 business days, people in jail don't always have access to the phones. Sometimes they're on lockdown. If the Animal Foundation is not taking calls on Saturdays and Sundays, those days will count against them, and that will hinder them from getting their pets back. And these aren't the animal abusers per se. These are just people that got arrested on the street when their pets were with them. So we do have a serious issue with changing the calendar days. The rest of their technical amendments we're fine with. The misdemeanor as the general statute, I think John Jones clarified that. I will say that I do like separating cruelty and torture as far as that. I think that adds clarity to the law. I would posit to this body that not feeding your animal such that it is emaciated and skinny and on the verge of death is an act. That's not an omission. That is an affirmative act. You are doing something affirmatively to hurt that animal. And so I do think that they would still be able to prosecute with these definitions being separated. But we're also open to tweaking that language. But I would posit that that is an affirmative act, not an omission. I think the length for the affirmative defense is fairly long. There are defenses like corporal punishment, and they go before a jury. And that's, if I got spanked, I grew up in that era, right? There are some parents that go too far, but they can put that defense forward, and then it goes before a jury, and a jury decides. I think a jury could decide that that was not adequate discipline. That was not hitting your dog with a piece of paper because they went to a bathroom in the house. That was over and above. And I think a jury would be able to recognize the difference there. So I don't see the same concerns that John Jones sees with that affirmative defense. And those are our comments on the proposed amendment. But as far as revision 1 of the bill goes, we would be in neutral. But if some things were to change, then we would change our opposition. We'd change into that position. I hope that was clear, even though it was.
Thank you. I think it was. I'm sorry. You're saying that if we accept the district attorney's amendment, you'll be in opposition.
John Pierre for the record, yes, Chair. But I think there's also some technical changes that Mr. Rogan is proposing that I'm not totally against, but I am against the business day proposal.
And that was going to be my first question to you, because you did mention that we worked together, my very first session, on a bill regarding returning animals to their people when that person is arrested. And it's my understanding that the current law is still that there is a different process if the animal was the victim of abuse versus just the pet of a person who got arrested. And I'm going to get a little bit off topic, but I think it is horrible to hear that a client's animal was adopted out before they had the opportunity to be reunited. And I'm wondering if that is a failure of the statute or a failure of implementation.
John Pierre for the record, I think it's a failure of implementation and on the Animal Foundation's part, and we're going to try to work with them. And then if they refuse to work with us, then we are going to come before this body next session and seek a perhaps legislative change.
Okay, that's kind of where my question was going, because absolutely I think if there's something legislatively we can do to prevent that from happening, I am always open to revisiting, prior work and improving it, updating it, things like that. I'll note I was not consulted on this amendment, so I'm a little bit dismayed to see so many changes to that chapter we worked so hard on. And then my other question was about the affirmative defense. I understand your position on the affirmative defense's existence. What about the additions in the amendment of subsections A and B requiring notice to the prosecuting attorney about the affirmative defense?
John Pierre for the record, we'd be open with talking to them about that.
Okay, perfect. I think those are all of my questions, but Senator Nguyen has at least one. Go ahead.
Thank you. I apologize to the bill sponsor for my tardiness. I was in finance. So I have had the opportunity to review this. I've been looking at the amendment that was proposed here. And then I guess I didn't realize that this was like an open case. So I know that you cannot comment on this, and I'm not sure. It looks like I'm getting a no. I guess then this is for you, Assemblymember Hardy. I know typically in this body, we do not like to involve ourselves in ongoing open litigation. Do you know how these proposed changes that have passed, that have been accepted by you in any of these proposed amendments might be applied? Would they be applied retroactively? Would they be applied to cases that are currently imposed? And I'm sure one of these lawyers might be able to help you out here, so I may call Mr. Jones back down here to answer that as well. But if you could just address that. I know that, we've always tried to make it a policy where we don't get involved in open cases, and I know this is a perfect example of why we don't do this, because it becomes a situation where no one can talk about it. So whatever you can feel comfortable within, your ethical guidelines, that would be appreciated, Mr. Jones.
Thank you. John Jones on behalf of the Nevada District Attorneys Association. Senator Nguyen, great question. I'm not going to comment on any open cases. I've taken great pains not to as we're presenting this bill. Even though I am aware of the the name of the bill. I can tell you that in terms of criminal penalties, the new criminal penalties outlined in section 1.4, those would not apply to any case that was, any act that was engaged in on or before the effective date of this bill. So some of the cases that have already occurred that are out there, the now existing, the current criminal penalties would apply. Now, with respect to the new animal prohibitions and things like that, that could apply to the case because those are more administrative in nature. So if a person who committed an act of animal cruelty now is sentenced after this bill takes effect, then the court could, pursuant to, I believe it's 1.6, not having the bill in front of me now, could have an order saying you cannot possess animals for the 5, 7, or 15-year period, I believe it is.
Thank you for that, like, kind of clarification. And I recognize I've been trying to keep up with kind of the ever-changing nature of the language, which is, you know, I'd like to say it's not typical in this building, but it seems to be more and more regular and typical of the process, which I don't think is necessarily bad. I do have concerns that some of the other pieces of legislation, including those brought by our chair, you know, were not consulted. I think we had, you know, 7 hours of conversation about wanting to make sure we have all the stakeholders in here to make sure that we get it right, instead of making some broad sweeping, like pretty like drastic changes. And sometimes those are necessary. So I appreciate you answering those questions, and thank you for your work on this.
Okay, I think we were in neutral testimony. It turned into questions. I don't see any more questions or anybody else here to testify in neutral. I do have to check the phone line for anybody in neutral on AB 381. AVH, is there anybody on the phone right now?
Thank you, Chair. There are no callers to provide testimony at this time.
Thank you so much. Then that concludes testimony. We will come back to you, Assemblymember Hardy, for any closing remarks.
Melissa Hardy for the record. I just want to thank you, Chair and Vice Chair, and all of the committee for your time and attention to this bill. I appreciate all the engagement, and I look forward to working with everyone so that we can get this bill to a place that it will pass. And again, just thank you. I know things are fast and furious right now in the legislature, so I really do appreciate this. Is a very important bill to me, and so I appreciate your time very much. Thank you.
Well, we appreciate you taking the time to be here and to answer all of our questions. With that, I will close the hearing on AB 381. I will open up the hearing on AB 344. I don't know how many more times I can put on the record that I know you all have to go to floor eventually. So we will not be offended if you disappear in the middle of your presentation. But hopefully we have a little bit of time to hear from you and ask some questions. So the hearing on AB 344 is now open. There's a little button that looks more like a sticker, and when you press it, it turns red. And unlike every other room in this building, when it is red, that is when you speak.
Thank you, Chair Scheibel and members of the committee. I'm Elaine Marzola, representing Assembly District 21. It is my pleasure today to introduce Assembly Bill 344 in its first reprint, which aims to modernize and improve various aspects of our judicial processes with a particular focus on child welfare proceedings and the appointment of attorneys in certain cases. Today I'm joined by Kelly Brandon, Supervising Deputy District Attorney for Carson City, and the Chair of the Court Improvement Program Legislative Subcommittee, who will provide an in-depth overview of the bill and also answer any questions that the committee may have. Existing law authorizes the appointment of a master or special master to perform certain limited duties in in proceedings such as family law, juvenile, and traffic matters. However, the title master is outdated and comes with a negative connotation. Therefore, AB 344 in its first reprint replaces the term master with judicial officer throughout the relevant statutes, providing a more accurate and modern title for these appointed officials. In addition, Assembly Bill 344 establishes a clear procedure for transferring child welfare proceedings between courts within Nevada, ensures the appointment of attorneys for indigent parents and children in child welfare cases, and revises compensation for appointed attorneys to ensure fairness and consistency. Chair Scheible, with your permission, I would like to pass the presentation over to Kelly Brandon.
I actually hit the button twice. I made it upset. Thank you. My name is Kelly Brandon. I am a supervising deputy district attorney here in Carson City. I also serve as the legislative subcommittee chair for the Court Improvement Project, which is part of the Administrative Office of the Courts for child welfare matters. I think in that role, it's important for you all to know what that committee looks like. It's a committee made up of all stakeholders. We have child's attorneys, parents' attorneys, judges, child welfare staff who are on the grounds working these cases. And so one of the rules of that committee is that in order for us to bring this to Assemblywoman Marzola, we have to reach a consensus. And so this is something that all of those stakeholders have participated in and reached a consensus on everything that's been put forward in this bill. The first section is regarding the change of the language of master. Originally, last session, it was proposed to change it to magistrate. That posed some challenges in some specific jurisdictions, and so it was reworked, working particularly with our family law stakeholders to ensure that that term now says judicial officer, and that was brought forward by two of our judicial officers from the state who had children in their courtrooms who asked them if the term master had something to do with them owning slaves. And while I don't believe that anyone thought that that's what that term would mean for our children who are coming into court, we want them to feel like they have a judge who understands them, and that's the way they understand the term from their limited vocabularies and their development and understanding. And so going forward, having that change be made allows that to not be a question, so that they understand that that person is making decisions for their case and is in a robe and is in that really important position, but not having that same racial connotation that some of our young people have asked our courts. The other areas moving forward are the transfer language. So the current statute doesn't apply or doesn't address how we transfer a case between a jurisdiction. Jurisdiction in child welfare matters can come in three ways: where a child is living, where they're domiciled, or where they're found. So if we find a child in Carson City and that child needs to be taken into the state's custody for their protection, we can do that. But where that case should remain for the life of the case is better served by where the family lives, where that child is connected, where their school is. So if they happen to be in Carson City for the weekend, but they live in Elko, ultimately we want a legal mechanism to move that case back to Elko. The transfer provisions that have been put forward are consistent with what's been going on in the state, but everyone's just sort of been doing things without a real clear process of how to do it. As to compensation, it changes really two sides of that. First, it changes the appointment process. The provisions used to say that a court may appoint an attorney, and it didn't indicate that they shall appoint an attorney. Practice across the state was that from when a petition was filed alleging that a child's in need of protection. So not at the initial hearing when they've been brought into protective custody, but once that petition's been filed, that courts were appointing attorneys if there were parents that were indigent. It also provides a definition of what indigency means that's consistent with its criminal counterparts to address consistency between those two areas of the law. And then regarding those appointments, it clarifies that in child welfare proceedings that attorneys should not make less than attorneys who are working on misdemeanor cases. Child welfare cases are particularly complicated, and one of the things that changed with the Department of Indigent Defense Services is compensation for criminal attorneys changed, and the compensation by statute for child welfare attorneys didn't change. And that compensation is also now dealt with on a jurisdictional basis. And so this allows jurisdictions to compensate those attorneys adequately. It additionally allows them to be compensated for time outside of court proceedings, which previously wasn't in statute. And the bulk of work in child welfare doesn't happen in a courtroom. It happens in mediations, it happens at child and family team meetings with the division, and it's important that parents have appropriate representation at all of those critical parts of that process to ensure that they're adequately represented throughout. And then it changes the provisions regarding termination of parental rights proceedings, that they would be compensated at the level of a felony level attorney We have multiple cases, both in our state and at the U.S. Supreme Court, that says that the termination of parental rights is akin to the civil death penalty. And it's important from our perspective that we reflect that in the representation of what people receive in terms of their compensation for representing parents in those proceedings, because it's a critical piece of a state's intervention in a person's life. I'm happy to take any questions you all have.
Thank you so much. Any questions from members of the committee? Senator Hansen.
More of a comment. I'm actually a licensed master plumber. In fact, you come to my office, I got my license, my master plumber's license on my wall. I think Senator Ellison may be a master electrician. So in my mind, master suggests a high level of competency and experience. So I don't know, I can understand because of the implications to slavery or whatever, but for me, we're talking about a legal term. And when I hear somebody who's a court master, I assume they have high levels of expertise in the field of law. So I'm okay with making the change, but I get uncomfortable. We're always trying to go back and clean up the language and change everything when we should probably try to figure out what the actual origin of the word is and explain that, rather than just try to do everything and make everything so politically correct that you can't even call in the future, is the State Contractors Board going to have to change the title? Instead of a licensed master plumber, I'll be a licensed expert plumber or something. So I think the bill's fine. Don't get me wrong on this. I'm voting for it, but just kind of a comment that sometimes I think we kind of spend a lot of time trying to make things so politically correct, rather than trying to explain that the word often has a much bigger and broader meaning than simply something that goes back to antebellum days in America. So anyway, I just want to get that on the record that I am a proud master plumber, and I hope that doesn't change in the future as we become more and more sensitive about words like that. So thank you, Madam Chair.
All right. Other questions? Senator Flores.
Thank you for the presentation. And I think you hit on it a little bit, but I do see throughout the bill where you mentioned that judicial officer or at their discretion can use any other title as long as it doesn't include the word master. But you don't foresee us using 14 different terms throughout the state, right? I mean, assuming from the feedback you've gotten and from the conversation that you had last session when you were trying to make some type of change, I'm assuming that was the general consensus and that you weren't getting a lot of pushback where they're saying, well, I'm going to use this term and I'm going to use this term over here and this term over there. And I think it sounds like judicial officer seemed like the general consensus, but you just want to leave it broad enough in case there was any pushback, they had that flexibility.
Thank you. So I don't foresee there being a lot of differences amongst... Kelly Brandon, for the record, I apologize. I don't foresee there being 14 different titles throughout the state. I think there are some jurisdictions that have already issued administrative orders in their courts labeling what would be their juvenile master something else. And so I think they'd like to maintain those terms. Those jurisdictions have referred to them as magistrates. And so I could see us having a couple different ones, but I don't foresee us having 14. I think the larger jurisdictions have people that they title magistrates for other purposes, and so that's where the complications coming in is really a rural difference versus a more urban jurisdiction, because they already have people holding titles.
Fair enough. Thank you.
Thank you. Any other questions? All right, I don't see any. Thank you so much for being here to present this bill and answer questions. We'll move now to support testimony on AB 344. We'll start here in person in Carson City. Please go ahead.
Thank you, Chair, members of the committee. For the record, John McCormick, John McCormick, Assistant Court Administrator at the Supreme Court. CIP is one of the programs in my portfolio. They're at AOC, and we've put a lot of work into this bill. I can address Senator Flores' question a little bit more on the titles if you would like, but it's important that we get this through, and particularly on the attorney compensation pieces.
All right. Thank you. I don't see anybody else coming forward to give support testimony in person, so we'll go to the phones for support on AB 344.
Thank you, Chair. The public line is open and working. There are no callers at this time.
All right, we'll go to opposition testimony on AB 344. I don't see anybody coming forward in Carson City or Las Vegas, so unless anybody's joined us on the phone for opposition testimony, AVH.
Chair, the public line is open and working. There are no callers.
All right, we'll give them a few seconds to call in for neutral while I ask if anybody in person would like to testify in neutral on AB 344. Not seeing anybody unless we have had any new callers join us, AVH.
Thank you, Chair. The public line is open and working. There are no callers.
Thank you so much. Then that brings us to the conclusion of testimony. Unless the presenters have any closing remarks, I will close the hearing on AB 344. I will open a work session on AB 344. I would accept a motion to do pass.
So moved, Madam Chair.
We have a motion from Vice Chair Flores. We have a second from Senator Orenshaw. Any discussion on the motion? Not seeing any. All in favor say aye. Aye. Any opposed, nay. The motion passes unanimously to do pass AB 344. And that takes us to our next hearing. Do I have somebody here to present AB 541? How about AB 550? Come on down.
Good afternoon, Chair and members of the committee. My name is Drew Cross, D-R-E-W-C-R-O-S-S, and I'm the State Forensic Program Director. Thank you for the opportunity to discuss the proposed amendment for AB 550. We'd like to offer a brief overview and then be available to answer any questions. We have worked closely with the public defenders and district attorneys recently, and it is hoped that the alterations address their concerns. We sincerely appreciate their suggestions and willingness to work with us to improve the statute, which will ultimately lead to better treatment for Nevada. AB 550 suggests changes to NRS 178.461, which allows for up to a 10-year commitment at a secure forensic facility for individuals who have been found incompetent with no substantial probability of becoming competent in the foreseeable future for any Category A and certain Category B felonies. The first section of change improves the wording to provide clarity on the intent regarding an individual receiving restorative treatment prior to being found permanently incompetent to proceed. The second change alters the process by which the district attorney notifies the court and the division of the intent to see a comprehensive risk assessment. The court then writes an order for the division to complete this. The next alteration reverts back to the original language. It was agreed by all parties that this best captures the process by which someone is committed to the division if the risk assessment determines the person does not need inpatient forensic care. Finally, individuals committed under the statute and who are placed on conditional release and eligible for discharge from conditional release, if it is granted, a slight word change was made from facility to state. This was done to encompass the state of Nevada, as the current language could be interpreted to mean the facility itself, which for individuals on conditional release might not be a state facility. We are hopeful that these changes address the concerns expressed by the stakeholders. Passing this amendment of AB 550 will lead to better treatment for individuals, improve efficiency of the risk assessment process, and lead to consistency across the state. Thank you for your consideration of this bill, and we're happy to answer any questions.
Thank you so much. So just to triple check, this is a friendly amendment from the District Attorneys Association.
Yes.
Okay, perfect. Any questions on AB 550? No questions. All right. Thank you so much for your presentation. We'll move into testimony. Anybody wishing to provide support testimony is invited forward to do so now in person. Please go ahead, starting in Carson City.
Thank you, Chair Seibel, members of the Senate Judiciary Committee. My name is John Jones, here on behalf of the Nevada District Attorneys Association in support of AB 550 with the amendment. I do want to thank Director Cross. Despite my numerous emails and phone calls, he still answered and replied, so I give him great credit for that. But I'm here to answer any questions about my amendment if the committee has any.
Members, any questions? All right, I don't see any. Thank you. And I don't see anybody else coming forward to give support testimony in person in either physical location, so we'll go to the phones, please, for support on AB 550.
Thank you, Chair. The public line is open and working. There are no callers at this time.
All right, anybody in opposition to AB 550? Don't see anybody coming forward, and I assume there's nobody on the line. So we'll go to neutral testimony. Anybody in neutral? I don't see anybody coming forward. We'll check one more time. AVH, is there anybody on the line?
Thank you, Chair. The public line is open and working. There are no callers.
All right, then I will close testimony on AB 550. Unless there are any closing remarks, I will close the hearing on AB 550, and I will open a work session on AB 550. I would accept a motion to amend and do pass. We have a motion from Senator Wynn, a second from Senator Orenshaw. Any discussion on the motion? All in favor say aye. Aye. Any opposed, nay. All right, the motion carries unanimously to amend and do pass AB 550, and I will assign the floor statement to a volunteer named Senator Wynn. Okay, with that, I will open up the hearing on AB 451 I will turn it over to my vice chair to open up the hearing on AB 451, which I will come and present now.
And at this time, we'll open up the hearing on Assembly Bill 451. Madam Chair, whenever you're ready. Excuse me, 541. Excuse me.
Thank you. Melanie Scheibel for the record from Senate District 9. AB 541 is a budget implementation bill. When we appoint attorneys or have state employed attorneys represent people in court who cannot afford to have their own attorney, those attorneys have to be paid. And so the way that we do that is now through the Department of Indigent Defense Services. NRS 34.750 still indicates the Office of the State Public Defender. The Office of the State Public Defender is part of the Department of Indigent Defense Services, so this updates the language to reflect the proper state agency that would process those reimbursements. Happy to answer any questions.
Thank you for that very detailed, in-depth, long presentation, Madam Chair. At this time, we'll open it up for questions, which I'm certain everybody has at least two. Seeing none, I'd like to invite you to sit back. And at this time, we'll invite those wishing to testify in support of Assembly Bill 541, either in Carson City or Las Vegas. Seeing none, we'll go to the phone lines. Support testimony for Assembly Bill 451.
Thank you, Vice Chair. The public line is open and working. There are no callers at this time.
Thank you. We'll stay on the phone lines, and at this time, we'll invite those wishing to testify in opposition to Assembly Bill 541.
Chair, the public line is open and working. There are no callers.
Thank you. Anybody in Las Vegas or Carson City wishing to testify in opposition to Assembly Bill 541? Seeing nobody coming forward, I think. Mr. Horn, are you coming forward? Oh, perfect. Just want to make sure I didn't inadvertently skip you. At this time, we'll go to those wishing to testify in the neutral position for Assembly Bill 541, Carson City or Las Vegas. Seeing none coming forward, we'll go to the phone lines for neutral testimony in Assembly Bill 541.
Thank you, Vice Chair. The public line is open and working. There are no callers.
Thank you. And with that, any closing remarks, Madam Chair?
After so much testimony, what can I say?
That is probably the best closing statement we've ever heard, Madam Chair. And with that, we'll go ahead and close out the hearing on Assembly Bill 541, and we will hand the gavel back to our chair.
Thank you, as always, for your assistance, Vice Chair Flores. At this time, I will open up a work session on AB 541 and would accept a motion to do pass.
So moved, Madam Chair.
All right, we have a motion from Vice Chair Flores. We have a second from Senator Wynn. Any discussion on the motion?
I'll hold my right, if I could, Madam Chair, but I'll support it to get out of committee.
Okay. Thank you, Senator
I'm
Hansen.
kidding.
Okay. All in favor say aye. Aye. Any opposed? Nay. All right, the motion carries unanimously to do pass AB 541, and I will take the floor statement. And I think that brings us to the conclusion of our bill hearings for today's meeting. We do have public comment still. Anybody wishing to give public comment here in person or in Las Vegas is invited forward to do so now. Not seeing anybody, we will go to the phones, please, for public comment.
Thank you, Chair. The public line is open and working. There are no callers at this time.
Okay, sorry about that brief pause. We were just checking our list of unfinished business. We do have a couple of bills I think we can work session. We will start with AB 105. AB 105 was heard in joint session about 2 months ago. I will hand it over to Mr. McDonald.
Thank you, Chair. Assembly Bill 105 revises provisions governing firearms. This was sponsored by Assemblymember Howdegee and heard during the joint hearing in March. You may recall this bill prohibits, under certain circumstances, a person from possessing or causing a firearm to be present in or within 100 feet of an entrance to a location known or reasonably believed to be an election site, including any location currently used as a polling place. And we have no amendments proposed for this bill. Thank you, Chair.
Thank you. Any questions on AB 105? Not seeing any questions, I take a motion to do pass. We have a motion from Senator Orenshaw, a second from Senator Wynn. Discussion on the motion. I don't see any discussion, so all in favor say aye. Aye. Any opposed say nay. The nays are Senators Krasner, Ellison, and Hansen. The motion carries to do pass AB 105. I will give the floor statement to Vice Chair Flores. And with that, we will move into a work session on SCR 3, Senate Concurrent Resolution 3. SCR 3.
Thank you, Chair. Jared McDonald, Research Division. Senate Concurrent Resolution 3 directs the Joint Interim Standing Committee on the Judiciary to conduct an interim study concerning human trafficking. This is sponsored by Senators Pazina and Donyate and others. Among other things, it must, again, study human trafficking, and the interim committee must develop a report and send that to the Director of the Legislative Council Bureau for transmittal to the 84th session. There was an amendment proposed during the hearing from Marco Rauda, I'm not sure if I have that name correct, of El Faro Consulting, who proposed the resolution to clarify issues related to oversight and survivor participation. Thank you, Chair.
All right. Any questions on this measure? Okay, I don't see any, so I would accept a motion to amend and adopt SCR 3.
So moved, Madam Chair.
All right, we have a motion from Vice Chair Flores, a second from Senator Wynn. Any discussion on the motion? Not seeing any. All in favor say aye. Aye. Any opposed say nay. All right, the motion carries unanimously to amend and adopt SCR 3. I will give the floor statement to a volunteer named, named Senator Pazina, because she is in our house and it is her bill. Thank you for the reminder. I was doing so many assembly bills, I almost overlooked that one. So I think that concludes our work session for today. We're just going to go have a brief pause. All right, that does conclude our work session for today. I do not anticipate having another meeting of the Judiciary Committee. That could always change, but I anticipate any further action will be taken in a behind the bar meeting. So I just want to take a moment. I know there are very few people here in the room, but there may be some more watching in their offices or certainly catching up tomorrow on YouTube when they've missed today's amazing meeting. I just want to thank all of our staff. Our staff is incredible. You are the best team in the building, if not the entire world. We are so appreciative for you always being there to answer our questions, to fix our mistakes, to help us look good, and to keep these meetings running smoothly and on time. And I just cannot possibly thank you all enough. Same to the committee. I always tell people in the building that I have the best committee because every single member here reads the bills, cares about the bills, asks good questions, participates in discussion, helps me when we have to make hard decisions on policy and process and procedure. And I'm just so grateful to every single one of you for participating. And I do also want to make a quick thank you to all of our frequent flyers here in Judiciary. You know who you are, people who come in and testify frequently, because we do have a lot of repeat subjects here in a good way. And I really appreciate that we have a building full of advocates and professionals who want to make Nevada a better place, and they take the time out of their day to meet with me, to meet with members of the committee, to meet with each other, to come to consensus, even when it's hard. And that is really the work that we've been tasked to do, and we were elected to do it, but there are dozens of people in this building who were not and who still take the time to get here every day and work hard to make all of our laws better for Nevadans across this state. So I'm very grateful to all of those advocates, all of the people who come in and testify and participate, all of the members, all of the staff, and it is truly my honor to serve as chair, so thank you all.
And Madam Chair, if I may take a personal point of privilege, as Vice Chair, I just wanted to say it's been a tremendous privilege and honor to serve alongside of you. You are an incredibly capable human being. You've been working incredibly hard, obviously testament to the amazing staff that we have in this building that allow you to do all that amazing work. But I think it's just been a privilege for all of us to be here. I've seen you maneuver bills that you personally don't like, but in the interest of justice, in the interest of working collaboratively with others, finding a middle ground on a bill that you originally said, I hate this and I'm not sure why we're doing it. And in the interest of just giving everybody a voice, sitting through long nights and making those amendments work. So I just wanted to thank you and say what a privilege it's been. And I think we were doing some research, and I think you are, the longest serving person on it, who's both a woman and has been the chair of Judiciary. I think you have that record now. So I wanted to acknowledge that you are the first in this building to do something remarkable, and it's just testament to just all the hard work you do. So thank you, Madam Chair. It's been an honor for all of us. I know that collectively is shared.
Well, thank you. Thank you all very much. It's a little bittersweet. I don't know the next time that we will be meeting, but until then, we are adjourned.